we're spending more money, and I hope we get some better results as a consequence. Because right now, we're sitting at, I think, 9 months, 8.5 months from application to initial examination, which I don't know. That is not acceptable in my view.
Yeah, these fees are coming together, and I agree with you. I do hope it comes with more efficiency that'll lead to more timeliness. We've gotten kind of used to on the patent side a year, especially for busy art units. AI technology, software-based innovations. It's just going to take several years, but I'll just see that kind of come back toward the norm. So patents, I think we'll call it a bit more of a modest increase. This is the first increase since 2020. Okay, so I guess that's something. 4 years, not a ton of time. It took effect January 19. I think it's the same date on the trademark side. 7.5% is basically the fee increase. A couple of little points here to make. Probably the biggest felt increase is on continuation in part. So patents, I think it was a huge increase, $4,000 increase.
Wow.
This is to sort of capture, honestly, it's probably just to get a lot more money from the bigger companies that keep filing more and more child applications to try to, continue the life of an app even after it's been, expired. So yeah, really increasing the price. It's a shame here because this is really the key way for patent holders. If you get that parent filing granted just before you issue, we typically recommend a child get filed in case what you're selling changes over time or competitors try to design around it. You can try to match what your competitors are doing to continue to sort of broaden that scope. That's going to be more challenging because it's going to cost more. And it sort of seems awful because the lift isn't that much bigger. It's kind of just a grab. So that was one of the bummers. I don't mind a 7-8% increase, with respect to inflation and coming up to speed. But that's kind of the really high level patent fee increase. We can obviously quote specifics and if we have time, but I wanted to talk trademarks. I think there was a much more substantial increase.
There was. Yeah, it's about 40% increase in fees.
Okay.
Pretty wild.
Yeah, that's big. And so basically it was 250 going to 350.
Yeah, it was 250 prior to the 18th, and now it's gone to 350. And then they've increased a bunch of other fees too. So some interesting ones that we can talk about really quickly. And I will say at the beginning, I've been doing trademark registration for the last 13, 14 years. This is the first big increase that I've seen in my career. At the end of the day, yeah, it's a significant increase, but realistically, compared to the rest of the world, the United States still offers a pretty good value for money from the trademark perspective. England, it's like $1,000 basically, right?
Wow.
So
right.
350 is not so bad, I guess.
I was talking with someone. I do quite a bit of networking, and one of the individual attorneys I was speaking with, they do a lot of filing in UAE.
Yeah. Oh God.
Emirates.
That's like $2,500 each.
Yeah, you're right. I was blown away.
It's crazy.
So it's not like we're quite at that crazy level. We're still in the hundreds, thank goodness.
Well, I mean, I will say, if these fee increases get us some better service from the USPTO, then it's well worth the increase in fees. But if we continue to get the same substandard response times, turnaround times, office action analysis, people are going to be upset about it. At least I'll be upset about it as a practitioner. But some other increases that are interesting. Basically across the board, everything is up, but they've added some additional fees, which are interesting to me. And I'm not necessarily opposed to some of these. So the insufficient information fee. So if we submit an application to the USPTO and they find that, we're not as thorough as we need to be, or they want more specificity. Specificity.
That's a tough one.
Usually that's not a tough one for me. It's weird. Well, if they have to come back to us, essentially, they're going to charge us $100 for that. And that could happen multiple times. So that stinks for clients. And then a lot of times for clients with really unique products and services, we'll do a free form goods and services description. So we'll think about how we want to frame up what they're doing, and then we'll type it out in as broad a possible way as we can. But USPTO is going to charge an additional $200 now for that luxury. This last one I kind of really like. If you do the freeform text box and you have over 1,000 characters in that text box, the USPTO starts charging you additional money. And what I like about that is it's going to disincentivize applicants from like doing the kitchen sink approach, where they just put everything in the application.
I guess that is good. Yeah.
So that's good. Registration fees have gone up pretty significantly, a couple $100. Petitions to the director, that one's gonna hurt. That goes from 250 to 400.
What's a typical petition? What are things that you might be asking for?
So a petition to the director would be, typically it's going to be like after you exhaust your office action responses. So you get your preliminary, then your final office action. And if you're still unsuccessful after the final, then you can petition the director to review the application.
Okay.
Petition to revive an application, that's probably the most common one. Either client doesn't necessarily get back to us and want to respond to an office action right away, or we miss a deadline because the client's dragging their feet or whatever. The petition to revive the application goes from 150 to 250. So we're spending more money, and I hope we get some better results as a consequence. Because right now, we're sitting at, I think, 9 months, 8.5 months from application to initial examination, which I don't know. That is not acceptable in my view.
Yeah. On the patent side, there were some new fees as well. I'll go through a few of those. So the IDS, which is the information disclosure statement, this is what is required to be provided at the non-provisional phase. This is when you as the attorney and the client, you've got to give all that you know to the examiner. It's a requirement for you to share. If you did a patent search, you have to tell the examiner all the results you found. And it helps them, expedites the process.
I'm giving it to you.
Man, well, so it's contagious. A lot of things are this year. Hopefully, there's a lot of things. Kind of a good news, Ben, is if you've got a lot of disclosures to make, now you got to pay for it too, which kind of seems a little bit sad. So 1 to 50, 1 to 49 is free, but 50 to 100, $200. You provide more than 100, it'll be $500 more. So if you throw a lot at the examiner, they're gonna have a charge for it. Yep. And then we were talking about before, the big new one is this continuation app. There is some clarification here. Yeah, and so I want to make sure I note, it isn't just any continuation, any child. So if you have that parent and it's getting ready to issue, you can still file that continuation. There's no additional fee, but it's the after 6 years of the earliest benefit date, and you're still trying to file another child. It's $2,700 after 9 years. So if it's been 9 years since the parent's been filed, your earliest benefit date is $4,000. So those are brand new fees, basically charging you additional sort of a premium. Things must be going well with your priority date on your initial patent. So give the patent office just more money. It's the same amount of work, but share the wealth in a weird way, which is interesting. So that part I don't love, but I think it's going to mostly affect, larger entities that have portfolios that they're reaching back on. And then just more drastic increases, 100% increase on claims. So just when your claim count exceeds 20, it's now not $100, it's $200 extra. Mm-hmm. So that's more than the 7-8% that they were quoting.
Yeah.
Patent term extensions are going up 119% from 1,180 to 2,500. And a few other things are a bit higher than what they stated. So yeah, these fees are coming together, and like I agree with you. I do hope it comes with more efficiency that'll lead to more timeliness. We've gotten kind of used to on the patent side a year, especially for busy art units. AI technology, software-based innovations. It's just going to take several years, but I'll just see that kind of come back toward the norm. And yeah,
it would be great. I mean, for years when I was a younger attorney, 3 to 4 months was pretty standard from application to first review. It's really hard to tell a client, registration is probably 14 months from now. What? That's crazy. Nothing takes 14 months.
Oh, okay. We're going to keep fees as sort of our top topic, but this is sort of a next in line news, with our new president in office, a lot of new executive orders being issued. Big mandate here, kind of across the board, all federal employees, butts in seats. So no longer really allowing telework. There's the IP article. I subscribe to Law 360.
Oh, cool. I haven't read that one. I was curious about that though.
Yeah. So basically 50% are, I mean, teleworking right now.
Yeah.
And I don't know the difference between teleworking and remote. It's ridiculous, but to me,
I
they're
think it's
about
the same thing, right? It's the same
I
thing.
don't know, actually. I think they're actually termed different. So telework might mean that you're, part-time. You're sort of hybrid. So telework means hybrid. Virtual means
Oh, interesting.
100% virtual. I think that's the terminology. So either way, there's a phased approach, but they've all got to get back in some physical office. And I don't know. Do you think that's going to make people more productive? It's kind of a bigger question of, are we more productive at home versus in the office, or vice versa?
Yeah, that's a good question. So, at least on the trademark side, most of these examining attorneys are working from home.
Right.
They're just like us, right? They work from
Yeah.
home office or whatever. But there's so many younger attorneys now working for the USPTO, and my sense is they just don't have the training or experience necessary to really do a good job. So, I mean, it's not so bad from my perspective if folks have to, go into the office and have a little bit more supervision in terms of the work they're producing. But yeah, I don't know how you do that, because there's got to be close to a couple thousand attorneys who work for the USPTO.
Right. Well, and I think a good distinction here is not everyone knows that on the trademark side, the examiners must be attorneys.
Right.
Whereas on the patent side, not at all. No, they may be attorneys, but it's not required.
Interesting. I didn't know that. I assumed that they were all patent attorneys.
No, examiners pass the patent bar, but they're usually, they've got some time in industry. They have a science degree. Then maybe they have, some acumen within that what's called an art unit space with a particular area of innovation. I think very few are, Juris Doctorates. So it is quite a distinction.
That's interesting. I didn't know that.
Yeah, and I've always wondered why that is. In office actions, right, where we get an examiner rejection, we oftentimes will come back with legal argument.
Right.
We're making legal arguments to them. Yeah.
Individual.
Yes. So that we're working with more of a technologist, right? Sort of a CTO.
Yeah. Okay. That's interesting.
Mm-hmm.
What are your thoughts with this article you read? What did they say about
US
examiners?
The USPTO has made teleworking part of its culture, even before this larger cultural shift, post COVID-19.
Yep.
The agency's website calls itself a model for telework in the federal government. And so this is kind of a reversal of that, of now mandating, and I'm quoting this here, the edict could impact the entire federal workforce, 3 million people total. Of course, that's all federal employees. And that's a statistic from the Federal Reserve of Bank St. Louis. According to the brief missive, agencies and departments must take all necessary steps to end telework arrangements and require employees to work in person full-time rather than hybrid agreements. Heads of agencies have some wiggle room. They've got exemptions when they're necessary, but it seems like it's, 6% of all federal employees are working in person right now, which I was staggered by. It's only 6%.
6%?
Yes, only. So 94% are currently remote.
What?
Yes. Yeah. Currently, about 6% of federal employees are working.
Well, there's your problem, buddy.
Yeah. Whoa. So there's a whole lot of.
Hey, you know what? I'm all for the telework and stuff like that, but you can't tell me 94% of people are cut out for, virtual work. They're not. I'd say less than half the people that I know, who are professionals are really qualified to be working from home and responsible enough to do it, right? Certainly not 94%.
I would say I hadn't actually read that top line. So yeah, it's a big stat. 6% is incredible. What in the world? So a little more, a little more supervision,
Some supervision,
accountability, and just maybe a bit more cracking of the whip, right?
Yeah, it'll be interesting to see what the Trump administration does with everything. I mean, I'm not super connected. I don't keep up on the day-to-day of the USPTO, but I know Trump is really, big up on getting rid of all the DEI initiatives, diversity, equity, inclusion. I'm not sure the USPTO has participated in that or not. I don't know if they have their own programs. I assume they do, but I don't know how many of those examining attorneys came through that program at the USPTO. My gut tells me quite a few.
Yeah. So we've got, quite a few changes going down. I think that's the biggest one. So I think maybe with, fees going up and office workers returning to office, we might get some more efficiency. So that's something we can hope for.
We'll see. Because I know that, at the USPTO, a lot of the the day-to-day operations jobs, processing mailings, the assignments bureau, all that stuff, I believe, is in person in Washington, D.C.
Yeah. Okay.
At the USPTO office. But yeah, I don't know how
Well,
you get all those examiners to show up to work in Washington, D.C. when they all live
all over the
everywhere
world.
else.
Yeah. Well, there's a new acting director. So last year, the director stepped down.
Yeah, did we ever figure out why they stepped down?
There was very little said. Very little said. It came right after the election results were in. So I think it was just perhaps a political decision
Okay.
for. Yeah,
I heard they resigned, right? But
it was a resignation. Yeah.
but I
Right.
hadn't heard anything about specifically why.
Yeah, it's Kathy Vidal. She stepped down, I think, in November or December, I think. So Koki Morgan Stewart, she's the acting director. She actually was acting, interestingly enough, right at the beginning of the Biden, what do you say, presidency?
Biden administration or whatever, yeah.
Yeah, and so apparently she's interim.
So she was the previous administrator working.
Previous interim, yep. And so I assume that they're working, Trump's administration working to name a new director right now. But yeah, she took a break from her senior counsel role at Melvany and Myers LLP.
Mm-hmm.
Yeah, so I'm reading this article as kind of remote work. We talked that artificial intelligence is interesting. One of his executive orders, Trump rescinded the Biden administration's 2023 AI. This is a security innovation using AI standard. And the order had required the USPTO director to issue guidance to examiners about inventorship in AI, including generative AI and other considerations. So it's kind of this additional requirement and layer for more guidance regarding AI that's no longer in place. So that's been rescinded by the Trump administration. And so maybe more, allowing more AI related inventions and perhaps being a bit more lenient on what can come through. So that's, to me, that sounds pro patent.
Yeah,
but also could mean less guidance, a little more work perhaps on the back end, right?
Yeah.
So
I felt even on the trademark side of things that if there was artificial intelligence in those goods and services descriptions, it's gonna get slowed down, inevitably. I don't know if it might be a separate, hoop, but it seems slower to me whenever we file an AI application.
Yeah. Well, I think, obviously AI is going to impact a lot of every area of IP. Copyright, I think, maybe is the nearest, and some of these particular, and one of these, I forget the case, but there's these deep fakes, right? And the Copyright Office is saying that there's an urgent need for legislation addressing AI created deep fakes, where we honestly cannot tell whether it was human made or not. Very fascinating. I don't deal too much with copyright really at all. We're still pretty focused on patent works. Do you see that, or have you heard anyone deal with some of that type of concern?
I haven't heard too much about the AI in terms of copyright filings or how that's gonna impact things. Certainly, I talk to clients almost every day about them using AI in their business, right, and how they're using it or how they're using it for marketing or advertising or branding. That's a big one. Folks use AI now for branding purposes, whether it's logo generation or coming up with a list of potential names for their goods and services. I don't have any real concerns about the naming convention side of things, but the jury's still out on what can you do with the logo, right? Who owns that logo, right?
Yeah, artwork, right? The artwork itself, you're talking, or you're saying,
right? So you don't own the copyright. If you have a AI generate a logo for you, you don't own the copyright. Do you own the trademark though if you use it?
Yeah, I would lean toward yes, right?
Because they have different public interests. Yeah, I mean, you can use an AI generated logo for trademark purposes, but you can't, register as a copyright.
Yeah, that's really good. Yeah, trademark being source identifying, right? As long as it's doing that main function. Who cares?
I can't help but think that a lot of these, there's so much AI generated stuff out there right now, content, right, that people are using, making money off of.
Yep.
It seems to me that a less than reputable company who is creating all this AI generated content for third parties, right, might come back later and say, hey, we actually own that, right? That's ours, right? And pretty easily be able to digitally track and trace the use of those creations, right?
Yeah.
So that's my biggest thing with clients is hey, it's the Wild West out there. I don't think I would at this point jump all in on AI generated content for my own business.
Yeah, it seems like it'd be worth it, to pay the designer on Fiverr, $500 and just
Yeah.
so
Go on,
simple.
99 designs, get one for $200, right?
Exactly. No questions asked. I paid for this on this date. It's
Yep.
fine. Anyway, that'd be my quick take. Don't save that $500 necessarily.